Hey there, Professor Fields here. We are in Module Learning Outcome 4.3, the Sources of Search Authority. This is AJ 170, Constitutional Law for Criminal Justice Professionals. So Module Learning Outcome for this is to analyze the sources of the law enforcement search authority and including related case law. So search authority, anytime that you perform a search, you got to have search authority. And there's three main purposes that give you authority: to gather evidence, to disarm suspects for self-protection, and inventory property that you've taken away from somebody. Now the first term is called a full search. The second is a limited weapons search, or search, stop, and frisk, which we've talked about this semester already, the Terry versus Ohio. And the third is an inventory search. That's when you take somebody's property away from them and you give them a receipt for it, such as when you store a car. Now, general searches are prohibited by the Constitution. In other words, I can't just go through rummaging through people's stuff saying, hey, I'm going to see what I can find. Sometimes we call that a fishing expedition. You can't go on a fishing expedition without probable cause to believe that there's going to be evidence found there. So the Fourth Amendment requires you to have search authority, and you also have to confine your search to the authorized search boundaries. And there's a couple of court cases listed that deal with that. Schimmel's been around since 1969, since way before I even went to the police academy. That's the main case in this. Boundaries. Boundaries have two features. They just define the scope and locations to be searched. In other words, I can't go looking in a bathtub in a house for a stolen car. I can't fit the stolen car inside that bathtub. And the intensity defines the thoroughness of what the search may be searched, how much time you have, other limitations like that. So full searches. Full searches are searches conducted to gather criminal evidence, and those are called full searches. And usually, if you have a full search, you're going to need to get a warrant. There's a couple of exceptions. One is urgent need for search at a time when it's impractical to obtain a warrant. We call that exigent circumstances. We're going to talk about that later on. A lot of the exigent circumstances you have. And the Supreme Court prefers that you have a warrant before searching. Number one, it places the decision of whether or not there's probable cause on the judge. So you take it to the judge. He or she says, yeah, you got PC. No, you don't have PC. Try again. There's also a presumption that a search warrant is necessary. In other words, if you don't have one of those exceptions, that search warrant is necessary. Another thing about a search warrant, it can shield you from civil or criminal liability, false arrest claims. Remember, I used to work legal affairs, so false arrest claims, you got a warrant that gets rid of that. And it can help insulate you from the suppression of evidence. You're more likely to get the evidence into trial if it's already been ruled upon probable cause than if you've done a search on one of the other circumstances and then had to go to, in California we call it a 1538-5 hearing, which is a motion to suppress. We'll talk about that later in the semester. So that's it for this segment. The next segment we're going to talk about the intensity of searches and the areas that the exceptions, including exigent circumstances. Thanks for listening.